George R.R. Martin, author of A Song of Ice and Fire, the basis for HBO's Game of Thrones, has been in the news a fair bit recently. Of course, the normal Winds of Winter clickbait stuff, but beyond that, there's been a lot of talk of this lawsuit that he's involved with. All of these headlines discussing that he's suing OpenAI for a number of different claimed reasons. And a lot of these articles don't fully communicate not only what is going on, but the basis of the lawsuit and how exactly George R.R. Martin is involved in all of it. For those of you who might not know, I'm a third-year law student, and I wanted to today take a look into this case, look through what has already been filed, where the lawsuit currently stands, and what it means for Song of Ice and Fire and AI generally, as well as some other recent flare-ups of use of AI and A Song of Ice and Fire that have occurred very controversially in the community in the past week or so. So buckle up, we got a lot to cover today. So, all of the headlines are saying George R.R. Martin sues OpenAI, but he is far from the only individual doing just that. This is what is called a class action lawsuit. A lot of individuals have similar claims against OpenAI, and they've all been bundled together into this one single legal action. That very much helps for establishing that there is some wider pattern of harm that is being inflicted, allegedly, on these authors that they are trying to recover for against OpenAI. George R. R. Martin is one of over 20 authors involved in this suit, and all of them are doing it under the name of the Authors Guild, which is this organization based in New York. With class actions, not all class members are necessarily created equal. And in this instance, the reason why George R.R. Martin is getting so much press as being so involved in this lawsuit is that A Song of Ice and Fire is kind of the example that is used as the basis for this claim. Specifically, the authors involved are claiming that the AI is not only being trained on their work and thus infringing it, but the work itself that it is producing acts as an infringement of the copyright of each author in question via either producing kind of recaps of elements of the book or creating new material based on and using the material of the author as well. And in this instance, A Song of Ice and Fire is the core example cited in the complaint, as there are instances of OpenAI kind of giving this a summary of the first book in the series, A Game of Thrones, or then trying to come up with its own sequel to A Clash of Kings that is complete dog shit in all regards, but regardless, it is using George R. R. Martin's copyrighted material to kind of try to create something of its own. That's one of the first big clarifications that I want to make in this video regarding the wider consensus on this lawsuit. Not only does it seem to be a good and necessary thing, as these claims that the authors are alleging are very much a real concern, given that their work is seemingly being used to train these programs, and it can be infringed upon at any moment by anyone with computer and internet access. Additionally, the main thing I want to clear up is that George R. R. Martin is very much involved in this suit. He is kind of the example being used. He is a member of this class. He is not the one litigating this lawsuit. All of the billions of comments I've seen online that, oh, he has time to do this, but not time to do the Winds of Winter. As far as I am aware, George R. R. Martin is not a lawyer and is not involved in this process beyond kind of being the genesis for it. With that said, this is a very long process. For those who might be less familiar with lawsuits, especially class action lawsuits, they take quite a while. Not only do we need to go through the typical kind of procedure of any given civil case, that being any kind of case that isn't involving a criminal charge, we have to certify a class and show that there is truly a claim here. This case was started on September 19th, 2023, and it is still ongoing. The most recent headlines, while eye-catching, don't necessarily describe any finality in the case whatsoever. I should also say, this is kind of the most I've blended my law school Quinn and Quinn the GM in a video. If you enjoy this, let me know. I'd love to do more stuff like this in the future, and be sure to leave a like and subscribe. I really appreciate it, and it does really help the channel, so thank you for that. The reason this case has been in the headlines recently is merely its survival. Throughout this very long course of any civil suit, there are going to be a billion motions filed by either side. Specifically in this case, at least, I was looking through the actual filings. I did not read all of them. I read a bunch of them, but there are 734 total documents filed in this case, but one filed last week is quite important. Any defense in a civil case is usually going to make a motion to dismiss the case, having argued that the plaintiffs, the people bringing the suit, have not sufficiently argued that there is any actual either harm or source of harm by them. In this instance, OpenAI brought this motion to dismiss, saying that this Authors Guild has not sufficiently alleged that any copying of their works has taken place. Specifically, they're trying to dismiss it on the idea that if it were to go to trial, no reasonable jury would be able to determine that there was copying of any kind that went on here. The case made headlines because this motion by the defense just failed. The judges have determined that a reasonable jury could determine that there was some copying that happened in this case. This doesn't mean that the lawsuit is going to be a success. This means that the judges believe that it could theoretically be a success. If there is any chance that a reasonable jury could find that fact, then it will continue on through the trial process. At this point, discovery is ongoing, and we are ways away from having an actual trial at any point. And at this point, it is worth considering what the potential end states for a lawsuit like this might be. The vast majority of civil cases settle at some point before the final verdict is reached, and even before a trial begins. This is kind of advantageous in a lot of cases to both parties. If you go to trial with any civil case, it is completely luck of the draw most of the time. A jury can do any number of things, and while there are a number of factors that can make it more likely or less likely that they will find in whatever direction you are hoping they will find, it is a lot more reliable to actually get together with your opposing party and negotiate some sort of outcome that can be decided out of court rather than actually needing some form of final judgment from a judge and a jury. In those instances, it can be good for the party who is seeking some form of relief because a settlement acts as a guaranteed form of relief. And for the defense, oftentimes settlements can be less than a jury would award otherwise. And additionally, settlements oftentimes don't carry with them the wider spanning injunctive relief that a verdict actually can, as in this instance, there is injunctive relief requested, that being the request that the court will order OpenAI to either do or not do something. However, despite how common settlements are in the average civil legal case, I am not sure that this case will settle. Look at the actual people who are bringing this class action. It's a bunch of very successful authors, and this is a very wide-spanning issue over a lot of elements of society with the advancement of AI. If I had to guess, the goal of this lawsuit is to have some decision cutting against OpenAI and their practices of not only training their models on existing works, but allowing those models to not only build on top of those existing works and kind of regurgitate elements of them to their readers. If there was some settlement, it could be kind of negotiated into it that OpenAI would be restricted from doing that as it relates to the parties' actions and sources of intellectual property, but that wouldn't really be wider spanning for future authors who might face this same problem. Oftentimes, this would just pertain to specifically the parties involved in this case, if it were decided as a settlement, as opposed to being an actual ruling by a court, which could act as a precedent for future cases. So if other authors were to bring a case against OpenAI, it would be a lot more likely to succeed, given the fact that there was this precedent. I've also seen a lot of people saying, oh, George R. R. Martin is doing this just so AI can't finish The Winds of Winter because he's not working on it. He does seem to be working on The Winds of Winter, and it is also worth noting that any type of AI that is attempting to recreate human art of any kind is not truly finishing or doing anything. Machines themselves cannot produce art. Art in itself is human expression, and A Song of Ice and Fire is something that is so full of this human heart and soul that can just really never be reproduced by anything. And additionally, it's going against the author's wishes at that point, and that really isn't any true conclusion to any series. But speaking of AI and A Song of Ice and Fire, there was a situation that came up last week that is quite disappointing in that realm. I should note that everything I'm about to discuss is alleged and it is unclear as to what precisely is going on, as no one has directly made a statement on it. But it certainly appears as though many of the illustrations within the illustrated edition of A Feast for Crows for that book's 20th anniversary, they look like they were produced by AI for a number of reasons. These including not looking like anything like the characters they're describing, no sigils or anything anywhere in anything. All of the characters are just wearing blue, and there are a number of oddities throughout the art that just don't really make sense, not only from a Song of Ice and Fire perspective, but just from a general, people perspective. I should also say, based on all of the information we currently have, it does not seem like George R. R. Martin was involved in the process of selecting any illustrators for this A Feast for Crows illustrated edition. I would not direct any hate in his direction, or frankly in anyone's direction, except maybe the publishers, just to see what is going on and ask for some comment there. Things like this art of Cersei that looks a lot like Show Rhaenyra, in which she only appears to have one leg, and this art of Tywin's funeral. This scene that is very directly described in A Feast for Crows, yet none of the details match whatsoever. Not only does Tywin look like Show Viserys, he's wearing a crown, which he really shouldn't be doing. It specifically said he's not wearing anything on his head. He has hair, but Tywin is bald. Jaime has long hair and no beard. Cersei's arm appears to be kind of clipping out of her stomach rather than being attached to her shoulder. The pommel is not attached to the hilt of Tywin's sword. It's tilted off at a weird angle. It's a bunch of hallmarks that very much make it look as though it is generated to some degree. If that is indeed the case, this is incredibly disappointing. Not only has George R. R. Martin made his stance on AI clear, this is a community full of so many talented artists that the company could have commissioned to create truly incredible depictions of this book that often is overlooked. So much of A Feast for Crows isn't adapted in Game of Thrones, and because of that, I think there are a lot fewer art pieces of a lot of scenes of A Feast for Crows. Hell, for A Feast for Crows' 20th anniversary, I made a retrospective video on it, and I had trouble finding pieces of certain scenes, given the fact that it is kind of a lesser discussed book outside of the most devoted fan circles. An illustrated edition could have truly been something great, but this version that we have seems, at a minimum, kind of half-assed. AI is depressing in its current iteration. I've always viewed it as something of a sedative for humanity as a whole, rather than expanding our minds and actively thinking on things, feeling things, developing things, actually having our own ideas. We are instead just, typing something into a box and relying on a machine to kind of spit something out that almost looks like what we're thinking of, but it really doesn't quite get there because there isn't any heart or soul in any of that. And beyond that, it tends to destroy the environment. If you notice your electricity prices are creeping up, has been said to be due to AI data centers consuming so much power. It's something that is a massive concern for society at this point, and it is something that is not really regulated at present. And I think a good way to regulate it will be through decisions of the courts regarding certain things like intellectual property. And that is why I personally am very excited to see how this lawsuit in which George R. R. Martin is involved will end up resolving. That might be years down the line at this point. Thank you all so much for watching. If you enjoyed this video, be sure to leave a like and subscribe. I'd really appreciate it, and it does really help grow the channel. I'll have more, less legally focused videos for you in the very near future on A Song of Ice and Fire, Game of Thrones, House of the Dragon, and A Knight of the Seven Kingdoms. I hope you enjoyed this one. I hope you have a great whatever day of the week you're having. I don't know what accent that was, but it just came out a little bit. I apologize. Goodbye, everyone.